This conference will now be recorded.
Okay, welcome everyone. Hi, I'm Peter Cleggis. I'm the president or chair of the Children's Law section of the State Bar, and we're doing this new knowledge today on fostering connections. The three presenters we have are Cass Brulotte from CYFD. She's a CCA who's been working with the department for a number of years and has a lot of experience when she worked in Alaska, representing tribes up there. And Sara Crecca, who's a long-term GAL in the 2nd District. She's worked as a GAL for many years, and she has also been involved in the Kevin S. as one of the lead attorneys that was involved in that case, which resulted in some changes. And then finally, Rebecca Liggett. Rebecca is now the chief children's court attorney after having spent years in the field and as the chief appellate attorney for the department, as brings a wealth of experience. And I know she was very involved in getting the new changes in our act, in the New Mexico Act, and in compliance with the federal act. So, in that being said, I'm going to just turn this over now to, or I guess Morgan is going to turn this over to Cass so she can begin the presentation.
Right, well, good afternoon, everyone. Thank you for joining us. As Peter said, I am Cass Brulotte. I'm one of the CCAs with the Children, Youth, and Families Department, and I'm going to be doing a quick overview, and by quick, I mean very quick, overview of the nuts and bolts of the Fostering Connections Act. There's a lot of information in these slides I'll be showing to you that I'm not going to specifically read to you. As noted in the chat box, you can get copies of these materials. I recommend you do so. All of the statutory citations are involved, and there's a lot of really good information, but I'm just going to be hitting the highlights today.
You're muted, Cass.
How did I mute myself? Thank you for somebody telling me this. Can you hear me now? Hey, the New Mexico Fostering Connections Act was passed in 2019, and the program first became live as of July 1st, 2020. Rebecca will be talking later about the history of how this program came to. The first question people want to know for Fostering Connections is who is eligible to enter this program. This program is designed for 18-year-old youth up to the age of 21 to provide them with additional supports after they have left foster care. The first criteria is that the child needed to be 18 years old on July 1st, 2020, or to have turned 18 after that. So this is an ongoing program that will be eligible for all of our youth who are turning 18 in the future, but they had to have already been 18 on July 1st, 2020 if they aged out when the program had started. There's two main groups of youth that will be entering this program. The first will be those who've aged out of CYFD custody. The primary consideration is they have to have actually been adjudicated while in CYFD custody and that they were subject to an out-of-home placement order. There is a second group of youth that will be eligible for this program if they were 14 years old when they were adopted out of CYFD custody or entered guardianship, and that agreement has been terminated, or the guardians and parents are no longer willing to provide support for that youth. That is a secondary group I will not be talking as much about today, as the bulk of our procedures are relevant for the youth who remain in custody from the age of 14 up until they are 18. They do have to maintain eligibility once they're in the program, and the eligibility criteria are listed on this slide as well as in the statute. The department starts working with youth at age 14. By the time a youth is 14 in our custody, they are assigned a fostering connections specialist as a secondary worker, who's someone who can begin working with them on independent living skills and developing life plans. Things really kick into gear at age 16 when the fostering connections worker and the youth and their team begin having regular transition planning meetings to discuss the transition plan to help the youth transition to adulthood. At every permanency review hearing that we have after a child is 16 and a half, we are now required to obtain findings that the youth has been notified of the Fostering Connections program and its benefits. They are being notified of this during their transition meetings with their Fostering Connections specialist, but we are now adding that to the prior findings you're used to seeing in our perm and judicial review orders. We have to have transition meeting updates throughout the time the child is in custody. So it's not just one meeting at 16 and then we're done. These things are continually updated with the youth throughout the time they are in care. By the time they are 17, when we are having permanency review hearings, we start filing that transition plan along with the permanency review orders so the court can see it. And at the last review hearing held while the child is in custody, the court is going to make a finding about whether or not the youth has decided that they are going to enter the Fostering Connections program. And this is in addition to those findings we started making at age 16 about how the youth has been notified of the Fostering Connection program and its benefits. And the final hearing we have for a child who's in custody, the discharge hearing, we will have that final review of the transition plan and also ensure the youth has all of the necessary documentation required by statute. These are pretty standard, not much has changed from what was happening before the Fostering Connections Act. But now we're 18 and this is where everything is very different. On or after the child's 18th birthday, if they've decided to enter the Fostering Connections program, they're going to sign a voluntary support and services agreement because this program is voluntary and it is not mandatory. This is helping the youth know that this is their choice. Once the youth and their fostering connection specialist have both signed this agreement, the CCA, has 15 days to file a new fostering connections petition. This will be an entirely new case. It is not a continuation of the JQ abuse and neglect case. 90 days after the petition is filed, the court is having its initial hearing. It can have it sooner, but it must be within 90 days. And they are making very brief findings at this initial hearing. The transition plan is continuing to be updated through this time. We started at 16 and we are now continuing until they're 21. The court will be holding review hearings in the fostering connections case every 6 months, and we must have an updated transition plan before every single one of those review hearings. These review hearings and reviews of the transition plan are going to continue until the youth leaves the fostering connections program. They can leave either by their choice, they can leave because they're no longer eligible, or they can simply age out of the program at age 21. That is our very fast timeline of the Fostering Connections program. Sarah's going to talk to you a little bit more about transition plans, which, as I've said, start when you're 16 and continue to be developed all the way until you're 21 if you're in this program. The most important thing to remember for this transition plan is that it is a living and breathing document tailored specifically to the youth. This is going to be constantly changed. It's going to be updated based on the youth's change in life circumstances, change in preferences, what they want, what they need, just changes in the world. So it is incredibly important to know that this document is not static. It is never set in stone, and it should always be updated. It must be updated a minimum of 5 days before each review hearing, though we do prefer it be closer to the 30 days mark, as everyone is aware that the court wants to see these filed 2 weeks before our review hearings. The Voluntary Services and Support Agreement is the contract that the youth and the department sign to enter together to work on this program. This is not a very unique document. It's not specifically tailored. It is a more generic form. The transition plan is where all of the specifics are. This is just to help lay out the responsibilities of the department and the responsibilities of the youth in order to maintain eligibility. Those criteria were listed on the first slide, but common ones, they have to be enrolled in school or be working at least 80 hours a month or have a separate situation where they are found to not need to engage in either of those two criteria. A common example would be a youth who has, say, just had a baby. We would not be expecting a brand new 18-year-old mother to be going to school full time or working 80 hours a month. And so that would be worked into her plan, how to maintain her eligibility while still allowing her to grow into her own role as a mother. So as noted, the petition that must be filed within 15 days of the execution, that is what is opening our Fostering Connections case. The Voluntary Services Support Agreement and Transition Plan are filed at the same time as the petition. They're not attached to it, but they are filed with it, so the court will have the opportunity to review these. These cases are not sequestered the way that our abuse and neglect cases are. So the CCA is also filing a motion in order to seal the case simultaneously with the petition. I am aware that they are looking at amending the statute and the rules to correct this, but unless or until that happens, the department is ensuring these cases remain sealed by filing that motion in order. Venue is a question for every one of these cases. We need to file the petition in the county where the eligible adult resides. Sometimes that might mean it is in the same county where they were in custody, and that helps dictate who the children's court attorney assigned to the case would be. If I have a youth who ages out of custody here in Bernalillo County, they choose to enter the Fostering Connections program, I will be the CCA assigned to that case, and I will be filing the case here in Bernalillo County. However, if that youth chooses to move to Santa Fe, then the case would be assigned to our Santa Fe office, and a different children's court attorney would be assigned to handle it, as we want these cases to be as accessible as possible to the youth. And one of the ways to do that is to make sure we are in the county where they reside. When the petition is filed, we also file a request for an attorney to be appointed for the young adult. The young adult may request that that be the same person as who was their prior youth attorney. It may also request it not be that person and that they be given an entirely new youth attorney. That really is at the discretion of the eligible adult. We will note it in our request that we file for the adult to be appointed an attorney so that the court is aware of who they do or do not wish to be appointed. At that initial hearing that's held 90 days, the two findings that the court needs to make for us to maintain our federal eligibility under this program is whether the transition plan meets the requirements of the Act and is the voluntary service support agreement in the best interest of the child. Those are the only two findings that we request at this hearing. The court will then order the department to make active efforts to implement the transition plan and work with the youth going forward. At our review hearings, which are held every 6 months, we are trying to make these led by the youth. These kids are not in custody anymore, and they're not in trouble. They're not being ordered to do anything. So we are really there for the youth. The hearings are, however, statutorily required, and the department will be requesting the court find that the department has made active efforts working with the youth to implement their transition plan. And the transition plan will be prior to this hearing, and the court will again note that it is appropriate. The court can order additional services if they feel the department has not made active efforts, or if they believe the transition plan is not in the child's best interest. I did mention earlier 3 ways that a youth can be discharged from Fostering Connections. And I apologize, I keep saying youth, it should be young adult or eligible adult. The first is by the eligible adult's choice. The eligible adult can leave the Fostering Connections program at any time. It is their decision to be in this program. As I noted before, there's no limit to the number of times they can opt in and out. If a youth enters in January, chooses to leave in July, they can come back in August and say, that was a mistake, I wish to come back into the program. We are going to continue to work with them. Another way that a youth can be terminated from the program is if they're found to no longer be eligible. This does require that there be a hearing, and it does require that the department have provided notice to the young adult of why we believe they're not eligible. We need to have tried to work with them to maintain their eligibility for the program, but it is possible that this path could be proceeded upon. And there will also just simply be a discharge at age 21, much as there were discharge hearings for our children in care who have turned 18. The discharge hearing is the absolute last hearing that is held before the eligible adult turns 21, we do still work with them on their transition plan up until that date. And so this final transition plan at the hearing is going to cover what's happening next, how the youth is planning to proceed going forward so that they are a self-sufficient young adult, aware of community resources, supports, and services that are available to them. This program is not intended to simply delay throwing them out into the wolves by age 21. We are still continuing to work with them, and we want to ensure that they are aware of every opportunity and resource and service available to them, even after they are age 21. And the court will, of course, make its final ruling about whether or not the department has made active efforts. So, in addition to this presentation, I do have a one-page version of the flowchart for people to post perhaps in their files on these cases. And we do have blank copies of a transition plan, so you can see what one looks like. And I know Sara does plan to go over with you, and a blank copy of a voluntary service agreement. If you would like any of these documents, please make sure you put your name in the chat. And also, if you have any questions at the end, you can either put them in the chat or we will be open for questions later. I hope I did not talk too quickly, but I believe my 15 minutes are up, and I will pass the torch to Sara.
Man, you did, it was like exactly 15 minutes. Okay. I'm going to try to open my document for screen sharing. Give me just a minute. Of course, I forgot how to do that. Oh, here we go. Okay. Sorry, technical difficulties. Okay, I think you guys can see the document. But let me get back into it. Okay, so this is just a little outline of what I plan to present. And of course, the purpose
Sara, all we see is a palm tree.
Oh no, sorry. Thank you. I tried this earlier and I did it. Hold on.
We saw it before. It looked, there we go.
Great. Okay, can you see the document without all of these other items?
No.
We also see some other stuff on your desktop.
Okay, well, that's fine. As long as it's not being blocked by everything else. Okay. So I can't see anyone anymore, but I know you can see me. I'm terrible with technology. Okay, so I just outlined a couple key areas that I think about as an advocate. I already have a case. And so having gone through the process up until the first hearing, these are some of my takeaways. So of course, the purpose of Fostering Connections is to wrap around and support youth who have aged out of the system. And these are young people who have experienced a number of traumas in their life, both in their family of origin and as well being raised in the system. So in order to provide appropriate support, it needs to be a program that's designed to build resilience and help connect young people with healthy relationships and support, of course, through housing, medical care, and financial assistance. And the reason that this program was developed this way is we're really aiming to avoid the outcomes we know are typical of teens who age out of care, including criminal contact, going to jail, domestic violence in relationships, unemployment, not finishing high school or getting their GED, furthering their education, or even worse, becoming themselves a respondent in the system. So this document, I start off with the advocacy begins with your teen clients. So we know that the transition planning meetings that used to be called the toolkit, many of you may have sat through some of these meetings already with your clients, is now converting into the moment where we will begin to develop the transition plan for post-18 with our 16 and up clients. So I really encourage you to make sure that these meetings include real goal setting, collaboration, and buy-in from your client, and is not just an exercise in checking off boxes, which it can be. I think it's really critical that the young person understand this. They may feel very meetinged out. Many of them have attended lots of meetings, but this is an important meeting, and the document that is produced is ultimately going to be the one relied upon when they turn 18 if they opt into this program. So it is an essential document. It's referred to in the findings on the record, and that is your tool for, as an advocate, for ensuring that your client's goals are really being supported within that document. I highly encourage support services early, so before 18 and post 18. I know that Fostering Connections and CYFD through Fostering Connections are providing case management. However, the more trusted adults in this young person's life, the better. I've already seen my client turn 18, and it's just very complicated. First of all, I've had to remind her a number of times she's not in custody anymore. She feels there's a lot of fear with young people. So the more people she has to turn to and rely on, you know, I'm just a lawyer, so I can't provide the kind of support a social worker or a mentor or a wraparound person can provide. So building those people into your client's life prior to 18 would be ideal, but it's not too late if the referrals and the encouragement to engage is after 18. So I've listed a couple of agencies that are local to Albuquerque, but in pandemic, I know at least New Day has brought a lot of their services online. So they offer wraparound support, which is another version of case management. They do counseling, life coaching, they have pregnant and parenting teen support. Their Life Skills Academy classes are online now. These are critical. I have had all of my teen clients ask me, you know, how do I save money? How do I pay rent? These are the kinds of things that they learn in the Life Skills Academy classes. Life Skills Academy at New Day also offers a class focused on building healthy relationships, which is another key element and foundation of the Fostering Connections Act. And again, the purpose of that is making sure that these young people know who to reach out to in a crisis. They are a lot of what they've experienced in the system, and then once they turn 18 and reconnect with biological family is really energized around chaos, crisis, and even violence. So I strongly encourage all of you to encourage your clients to engage in some of these programs prior to 16 and certainly after they turn 18. New Day also offers transitional living, which is supported housing and is another option for housing under the Fostering Connections Act. And I know NMCAN does an amazing job having mentorship, their Back on Track program, and really supporting people, young people who have aged out. So I say reach out to everybody and anyone who can support these teen clients. On the signing and execution of the Voluntary Services Agreement, definitely go over that with your client. It's really important that they understand what's in it. There are some provisions on the second page of it that allow and anticipate for the department to have access to medical records. That's something your client needs to be aware of. The VSSA doesn't address this, but I strongly recommend that you engage your client with the department in establishing a bank account the second they turn 18. Direct deposit of their payments is critical. Many of you may have heard from foster parents or otherwise in representing young people in custody that the reimbursement system is complicated. And that is essentially they're using the system they have in place to make payments to these young people, and there's a lot of delay built in that direct deposit at least helps alleviate. So I recommend that highly. The department has required that the young person sign the VSSA together with their case manager. As an attorney, I think you should be involved in that process. I think you also need to ensure that the case manager also signs it on the same day. The reason is that sets the clock into motion on the 15 days the agency has to get it finalized and get the case filed. So I shared some links earlier by accident in the chat room about adjacent legal services. One thing you'll be called upon in supporting your now adult client is providing legal assistance, if not direct advice and advocacy in other areas. So for example, there are frequently domestic violence issues that maybe need to be addressed, temporary restraining orders and otherwise, landlord-tenant issues, explaining benefit eligibility. And this can be done in part in some cases along with the case manager and the support of CYFD, as the case manager really has a lot of duty in assisting, especially with benefit eligibility, but also some landlord-tenant as well. But really, your client will be leaning on you to understand these systems. It's a scary world for them, and they need a lot of assistance navigating these things. So I provided some links. The first one is the renter's guide. So it's a full, complete landlord-tenant explanation of rights. And then the NM Courts is a starting point for the forms around protective orders, domestic violence, custody issues that may arise. Client contact. So a couple of things. I think we all need to reiterate over and over to these clients, you are no longer in custody. I think especially aged out young people, that's all they know. And so again, they're interacting with a case manager, and their attitude towards it is initially going to be like that's their PPW. And it's not. It's a different relationship. I find myself explaining, you're an adult, you don't have to say who you're inviting to your apartment. You're on your own now. So I think that's a burden that's going to be very difficult for the department to overcome, is transforming that relationship. And I think as advocates, we need to not only energize that and articulate it to our teen clients, but also hold the department accountable for their end of the bargain, which is, this is no longer a child in custody you are making decisions for. This is an adult you are supporting through a process. I said it's an emergency because the other thing I've noticed is these young people are very used to getting attention in a crisis. So you may not hear from your client, your young adult client, and then all of a sudden it's a 10 p.m. text and the sky is falling. And that just tends to be the way young people raised in the system have understood relationships and getting their needs met. So just a little forewarning, there's going to be some boundary building between you and your clients, but also maybe some non-traditional accessibility via text on weekends. They really are out there on their own. They need a lot of support, which brings me back to my earlier point of the more trusted adults in their life, the more support you build in, the better it is for them. For active efforts finding and protecting the record, I think the department and everybody is navigating what that means. I know that in other areas of the law, it's not exactly clear, and it's certainly not clear in this one either yet. I think the department knows it means something much more than reasonable efforts. I think that as advocates, it's important for us to ensure, and you can read the Cassandra provided or will provide via email the program instruction guidelines from CYFD. So it's the internal policy guidelines on how to implement fostering connections correctly. And you'll see that there under services, there's a whole list. I highly recommend you review those. A whole list of expectations around case management, and it's very different than a PPW. So it's something much more than handing a phone number to your young adult client who's a parent about parenting classes. And I think as an advocate, we want to make sure that rapport building is there, the connection is there, and that the active efforts are there around the services that these young adults are entitled to. Which brings me to ensuring the culture shift happens. Your client is not in custody. Again, you'll have to energize that in a number of ways to the client. And I would like to end with the quote from Secretary Blaylock. We found that it took a while for the culture shift to happen. He's talking about California rolling out the Fostering Connections Act. You had some workers in some places who were treating extended foster care as a privilege and not a legal entitlement. And we were actively pushing kids out if they weren't doing all of the things. I don't think we're going to make that mistake in New Mexico. So as advocates, let's make sure that that doesn't happen, that we really hold strong and make sure that the department is held to what it's promising, and that your young client is not re-experiencing really the trauma of being at somebody else's mercy instead of being supported into adulthood in a way that they're making their own decisions and they're having healthy relationships, they are succeeding in their goals. The transition plan talks clearly about what those goals are, and the agency is holding up their end of the bargain. So that's my 15 minutes. Thank you, guys.
Thanks. So can we switch over to Rebecca? Rebecca, can you unmute yourself?
Okay.
Yeah.
I'm going to try and do.
I don't have anything to share on the screen, so the palm tree is nice. If you want to leave that up, I'm sure it's fine. Hi, I just wanted to provide a really sort of high level overview of the Fostering Connections Act and where it comes from and what it's intended to do. So in 2008, the federal government passed the Fostering Connections to Success and Strengthening Families Act, and that act provided for extended foster care or foster care to 21. And so New Mexico's around the high 20th in the states to adopt extended foster care by passing the Fostering Connections Act in 2019, then with some in 2020. So at heart, what it really allows the state to do is to pull down these federal dollars, the $40, to as payments, to maintenance payments for these young, the eligible adults from 18 to 21 years old. And then Cass did talk about there's another group, but it's who were in adoptions or guardianships at 14 or after, and that those disrupted. So after 18, that they're not still providing support. But basically, so it allows us to pull down those federal $40, which is really important to the state. We were providing transitional living services and paying through our state general funds, but being able to leverage those federal dollars allows us to do more, to put in more supportive services for these young adults. The way that those federal dollars happen is through that VSSA that Cass and Sara both talked about. The Voluntary Services Support Agreement also acts as a voluntary placement agreement. So the eligible adult is voluntarily placing themselves in the placement and care responsibility of CYFD. That does not mean legal custody, as Sara stressed, but allows this collaborative relationship with the eligible adult. And the thing that allowing the eligible adult to come into the Fostering Connections program through the Voluntary Placement Agreement, or VSSA, is that they become their own budget group. So right now, if that youth was in foster care at 17, they may not be eligible for $40 because it's based on the home that they were removed from, the income there. And we have a very, very low saturation rate for 40 eligibility. So when the eligible adults become their own budget group, the saturation rate goes the amount that are eligible for the $40 goes up into the 90th percentile and close to 100. The Fostering Connections Act sets up this graduated system for bringing the eligible adults into the program, and Cass talked about that, starting 18 or over, when they turned 18 after July 1st of 2019. CYFD is working to get every youth who had turned 18 at July 1st, 2020 on, and we're looking back to try to get all those youth who turned 18 July 1st, 2019 into the program. And we have set up a way to get all those young adults into the program. Right now we have 50 eligible adults in the program across the state. And we're trying to get in, I think it's 60 some more by the end of the year. So then after that, when, once we get those in, that it will just be continuing to, when somebody turns 18, that they will be able to opt into the program, and we'll get them into the program right away. So I did want to talk a little bit about how Sara talked about transforming the relationship, and that is a really critical part of this Fostering Connections program. That these are adults, they're not children, and they need to have their own agency. And we're really starting earlier to work with this age population, the transition aged youth, starting at, really starting at 14 with the Fostering Connections specialist working along with the permanency planning worker, but then at 16, that really working with the Fostering Connections specialist and the youth to really start developing those transition plans that will continue with them and build and amend as they go along. So we at CYFD added 26 positions to work with this age population. 2 of them are bureau chiefs, and there's 24 new Fostering Connections specialists that are in the process of hiring all those people right now. So I think that is part of what will really help to transform these relationships. I think everybody working with this age population can also help transform these relationships as we go into these Fostering Connections program, because there's things built into the act that you want to make sure that the courts are looking at conducting the hearings in a manner that really supports the eligible adults' participation, including maybe different times to have the hearings. You might want to look at different ways to hold the hearings, and because they really need to be driven by these eligible adults, as the transition plan is too. So I just wanted to say like a couple more things, that the active efforts requirement, that's unique to New Mexico. When we were working on amendments to the Fostering Connections Act in 2020, that was a really important thing that people felt would really help to further support this age population to really achieve permanency, because obviously they haven't achieved permanency if they aged out of foster care at 18. So it recognizes that, and recognizes that because they aged out at 18, that they need further supports. And so making those active, not just reasonable efforts to ensure that the transition plan is implemented, that it's really meeting the needs of the eligible adult. And active efforts is defined in the Act as a heightened standard that is greater than reasonable efforts that include affirmative, active, thorough, and timely efforts. That's really taken from ICWA language, those people who are familiar with working with those cases. And so it's a really important standard to that it's increased. Another way that we're really looking at again, transforming relationships is looking at that best interest determination. So the court has to make a best interest determination, but it's not the same kind of determination as a court would make for a child. It's not some kind of substituted judgment for the eligible adult. They're really being asked to make a finding about whether continued placement and services are beneficial to that young person and really serve that young person in making their transition to adulthood. And I think probably most people will agree that in almost every case that's true, that the Fostering Connections program is beneficial in order to do that. But it's still the transition plan, the way the hearing should go, the work that CYFD does with the young adults, and the work that you all will do as their attorneys all need to be really driven by the adults in the case. So I think that's the last. Oh no, I wanted to say one more thing, and that is that the payments that for the eligible adult is $750 a month unless they're pregnant or parenting, and then the payments monthly are $1,500 in order to help further support that population. So.
Do you have anything else you want to say, Rebecca, at this point?
No, that was all I had to say. If there's
Okay.
anything, I'm happy to answer.
Yeah. If people want to, I don't know if you can get on or if you have to add it on as a chat, but please feel free to ask questions. I'll kick it off. I have a couple things. I wanted to clarify with something that I think I missed or didn't understand. If an 18-year-old opts out, does not join the program immediately, can they opt back in?
Yes, Peter, they can. So they don't have to decide to enter the program right on their 18th birthday. We will definitely have talked to them about it before they turn 18, but they will still have their fostering connection specialist. They'll know who that person is. And so they will be able to, and they can get some minimal supports even when they're not in fostering connections through their specialist. So they'll be able to contact their specialist at any time and ask to opt into the program.
Okay. And does the fact that a particular kid might reconnect with their bio family, does that a factor at all in continued eligibility, or do we know what the impact of that reconnection is going to be?
That is not a factor for eligibility. We're actually, part of the active efforts we're required to continue to make is to find permanency for these youth, these young adults. And that does often include reconnecting with biological family who may not have been involved in the past or may not have been approved as foster placements, but that's not a factor for eligibility.
Do you, I know that you talked about active efforts, and I think Sara mentioned that or one of you mentioned that there's a program guide about active efforts. Have you guys shared that yet?
That is one of the documents that we do have for the people who have put in the chat. It's the PIG,
Okay.
the program guide. So anybody who requests Morgan send them the documents, we do have that for them. I did not personally show that document. I was trying to give us less dense legal reading, but it will be accessible for everyone to review.
I don't think it actually mentions active efforts, but it talks a lot about the services to be provided, and it talks about placement options. So I think there's an argument to be made that this is a minimum, and that the very long list of services under service provision section of the it's called program instruction guideline that can be shared with everybody is a really good place to start when deciding whether active efforts have been provided.
And Rebecca, do you know if there's any plan to put these into procedures?
Yes, so the program instruction guide CYFD issued to staff for the interim until we get policies and procedures in place. And so we will be working on those.
Okay. And my last question is, you guys are, Cassie, you're talking about venue and all. So let's say young adult is in the second in Bernalillo County, starts out there, and then they decide they're going to move to Socorro or something. what happens to the case at that point?
There's not a specific plan for that. The case has to be filed, initially according to the children's code where the child resides. If the child, youth, where the youth or young adult, I'm going to get it right, where the adult resides. If they move during the life of the case, as we've noted, these are supposed to be driven by the needs of the young adult. So if they want their case to be transferred, I believe that it would be very possible to make that happen. It's just something we would look at, much like our transition plans, on a case-by-case basis to meet the needs of the young adult. They may wish for their case to stay where it was. They may feel comfortable with Judge Ward, who may have been the judge that had their case all along. They may, and especially right now, as we are doing so many remote hearings, there wouldn't necessarily be a transportation burden. So we would work with them on what they and their attorney thought was best.
So there's a couple of questions that have been put up in the chat. So I guess I can just go ahead and read them. From Beth Gilead, does the amount of the subsidy that the kids are getting increase if there's more than one child? And I'm assuming she's mean more if the young adult is parenting more than one child. And does the amount depend on whether the parent lives with the child?
So I'm working on getting an answer to the first part of that question. I know I've heard it and I don't remember, so I promise I will get back on that as soon as I hear. I do not believe, though, that it matters whether the parent is living with the child. The child can't be in like CYFD custody, but other than that, as long as the parent's rights are fully intact, that it doesn't matter if they're living with the child or not.
Okay. And then the other question I see up on the chat is from Shasta Inman. She said, can we hear about common road bumps on the legal/program/advocacy side so far, and how have these been handled thus far?
I would defer to Rebecca for that one, as she does have the more statewide view. I'm familiar with a couple of cases myself in Albuquerque, but this is a statewide program, so I'm sure Rebecca has seen the larger issues.
So I haven't heard about really specific road bumps. I think the legal side was it was filing the sealing orders and getting those done. And because I think it was really an oversight that these cases weren't sequestered, and we're working on changing that so they are automatically sequestered. So I mean, some of the kind of issues that have come up is that we've had cases where we've had now young adults on like the DD waiver or ones who have competency issues. And there's a case out in the southwest part of the state where the eligible adult, she signed the VSSA, but then after that was appointed a guardian. And so we're kind of like dealing with how do we deal with those issues. Many states for those kind of don't include that population of youth in their fostering connections program, and we're trying to maximize the participation. So that issue came up. And I mean, I have been hearing that the cases themselves are going fairly smoothly. And I know that the first case that Sara and Cass had in Albuquerque was a really complex case. But for the most part, they're kind of they're going along pretty smoothly. I don't know about the advocacy side. I can't speak to that.
Yeah, I'd like to address that. So there's a couple things, especially when your client is a parent, they are subjecting themselves to increased scrutiny around their parenting. So Sky reports may be made, your access to those and their access to those reports are limited. The department's involvement in determining whether or not your client should become a respondent is something you're going to have to be dealing with if they're parents. On the placement side, the program instruction guideline lists placement types because, again, the department is responsible for the care and placement of the young people who opt into the Fostering Connections program, and it lists a number of, it's useful in its list, but what it doesn't list is motels. And right now the department's heavily relying on 2 motels in Albuquerque to place young people. Some aren't even 18, but some 18 while they're waiting to get into apartments and have the program funded, have the leases signed, etc. And these motels are not appropriate placements. So that's something to look for if your clients are aging out of the system here in Bernalillo County.
Okay. Yeah, Cass responded to a comment by Nicoletta Spilka, and where she had a case, Nicoletta had a case out of Valencia, but the client is living in Roswell. And I guess that's just a statutory issue, right? Is that correct, Cass?
Yes, so we have to file the cases. The case begins under the statute in the county where the eligible adult resides. So it would have to be filed in whatever county they reside in, but it is just the general venue and transfer statute for all of the Children's Code 32A 1-9, and it does allow a transfer if the residence of the eligible adult changes or for other good cause. And I believe the goal of these cases, of course, is to work with the eligible adult. So there would just need to be a request made to transfer venue for what your client put forth as their reason for wanting it to be in a county other than the one where they are currently living.
And then there's another question: which CYFD attorneys will actually file the cases? And then I think we clarified this, but the other follow-up was, or are they filed by the youth?
They are filed by the CCA. And so that's why the signing of the VSSA, which Sara mentioned, that the voluntary agreement, once the youth and the Fostering Connection specialists have signed it, the department has 15 days to file the petition from the date of both of those signatures being on the document. It will be, if it's in the same, if the eligible adult resides in the same county that they did when they were in custody, it will be filed by the same CCA who had their case before. If they are in a different county now, then the managing attorneys in the department will assign that eligible adult's case to a new CCA who works out of the appropriate county. But it will be filed by the department.
Okay.
I just want to throw in too, if the young person decides not to continue with their current youth attorney and they request a new attorney, the administrative office of the courts will assign one to them. And that is actually all taken care of. Who the attorney is listed in the VSSA, and then the department has the court enter an order appointing the attorney. So either naming the former youth attorney or naming the new one provided by the AOC.
So I know, Rebecca, you had said that the department is planning to add a number of other more workers right now. How many workers are currently doing the job for the 50 kids that are in this program, or 50 adults that are in this program?
I am not sure how many. It's the same, the youth transition services staff who are doing it. I think there's under 20. We doubled it plus. Not sufficient for sure. Yeah.
Okay. And so there's a couple more questions that have come in from Beth Gilia. How is CYFD really dealing with the transition from what has been more a traditional adversarial posture, or at least more of a control posture with the youth in a JQ case, to a more collaborative posture in the Fostering Connections case? And are there any ethical issues that you think are occurring or could come up with the fact that the CCA may be the same in both cases?
I mean, I certainly don't think there's a problem with the CCA being the same in the JQ case as in the Fostering Connections case. The only time that, and we've talked about a little bit, is we come up that if it came up like a CCA, if an eligible adult's child came into custody, and obviously we want to do everything that we can to prevent that from happening, but if they happen to, the CCA couldn't be the one to file that case. That would, I think, be a pretty clear conflict.
I just want to point out there's absolutely ethical issues when you have a client who's a parent and the department is receiving Sky reports on the child. Case managers communicating about that to the client without your presence, access to the Sky reports, all of that creates a whole host of ethical issues that the department really needs to figure out some boundaries around. And that as advocates, we need to be prepared for it. If your young adult client has a child, definitely prepare and be on the lookout and actively requesting information around Sky reports if that's an issue, to keep your client informed.
And then for Cass and Rebecca, what about Beth's first question about the how do you change the culture sort of in that process? You have some of the same players going forward. How do you, what's the challenges you guys see in changing that culture to a more collaborative process?
Well, I mean, part of it is training. That CYFD, we're bringing on new people and we're training them in this. There's a Fostering it's called the Fostering Success Coaching, Academic and Career Transformation. So we're having this training and coaching model for our workers to teach them how to come at these relationships differently. And so I think it's all around is that everybody involved, the CCA, the people as attorneys who are representing the eligible adult, and the courts all need to approach these cases that this person is an adult and that they are the ones driving the cases. It's for their benefit. So, I mean, this is a small example, but I was in a meeting and somebody suggested, like one of the judges suggested, like having hearings every 3 months. And we've hired a couple people instead of every 6 months, right after the initial hearing. And we've hired a couple adults with lived experience for the department, and one of them was at that meeting, and her reaction was, they should ask us, like, do we want a hearing every 3 months? Not just automatically doing it, because it's not supposed to be as attorney and court driven. It's really supposed to be stepping back and letting this young adult have as much agency as possible. So I think it's just, that's it. We just have to come to the practice differently, and we'll keep learning because it is a shift in practice, I think, for all of us. And I mean, CYFD, like we're implementing it, and there's like a couple more years to like just completely roll it out. And we know that we'll learn from that. And I hope, like the system in general will learn from that, and we just keep working on those relationships.
Okay. There's one more question. If say you're representing the young adult in this program, and in fact there is an abuse neglect case filed on that young adult's child, what's the attorney's relationship to the representation of the now respondent adult in the abuse neglect case, or is there a separate attorney assigned?
I would imagine there's a separate respondent attorney assigned. I think there has to be. Otherwise, I don't think you can really function well in the dual role. I see the temptation there, but I think there needs to be additional counsel.
Cass and Rebecca, you guys have any thoughts?
I agree with that, with what Sara said.
Okay. Well, I'm not seeing any more questions. I'm out of questions. So I really appreciate everybody's participation and all. Thanks to everybody for showing up, and thanks Sarah, Cass, and Rebecca for sharing your thoughts on this process. And I know that there's a potential CLE scheduled for November or being planned for November to get more into depth on this, and hopefully we will all be able to learn more as we go, and we'll have more experience at that point.
Mhm.
Okay.
Thank you, Peter.
Thank you, everyone. I think we can end.